$1,000.
Okay, so then a $2,000 bond on the battery family violence.
Welcome to one of the most emotionally charged bond hearings we've seen all year. Today's case centers around Anthony Jerome Bowie, a father facing family violence charges, but the alleged victim is his own son. The courtroom is tense as defense attorneys argue Mr. Bowie was wrongly denied bond. They say he's not on probation. He lost his job while incarcerated, and the alleged victim, his son, isn't afraid of him. But things get even more complicated when the son joins the hearing via Zoom and reveals they've lost their home and are bouncing between friends' couches. What starts as a bond request quickly unravels into a deep conversation about poverty, parenthood, and the emotional cost of raising adult children in hard times. Judge Boyd doesn't hold back. Canned, trust me, you're going to want to see how this ends.
Mr. Bowie, raise your right hand for me. This is not Mr. Bowie, is it?
This is Mr. Bowie.
Oh, okay. I'm sorry. Motion to revoke bond for Mr. Anthony Jerome Bowie, 2025 CR 03122.
Judge,
It's a motion to
set bond.
modify the set bond, Your Honor. It was continued. The state objected for it, the hearing.
Oh,
to
that's
the
right.
same
I'm
day.
sorry.
Yes, Your Honor.
Motion to modify bond. All right, you're good, Mr. Bowie. All right, so it's the defense motion. Go ahead, sir.
Judge, so Mr. Bowie is held in custody with no bond on his charge. We had some discussion about this, but initially he was denied bond by the magistrate court because they had information that he was apparently on probation at that time. However, at this time, and I believe the state will concede this point.
Here, the defense makes a crucial legal argument. Mr. Bowie was originally denied bond because the court believed he was on probation. But now, even the state concedes he's not. That means, legally, he's entitled to a bond. It's a sharp pivot hand. It shifts the power dynamic in the courtroom. Pay close attention here. The defense is using recent revisions to the bond code, specifically highlighting Mr. Bowie's indigence and job loss. That's smart lawyering, leveraging not just legal precedent, but also human vulnerability. The judge's response will determine whether this man walks free or remains locked up without cause.
Mr. Bowie is not on probation in any jurisdiction, so he is not a probationer. So our argument is that provision of the code does not apply to Mr. Bowie at this time, and he is entitled to a bond on his misdemeanor case. I also, Judge, from the time that Mr. Bowie has been incarcerated, he did lose his job. And I believe that under the bond code and additional amendments to that, one of the inquiries that the court needs to make in setting a bond is the defendant's ability to pay. So Mr. Bowie is indigent at this time, and we're asking the court to set a very reasonable bond in his case. I believe that because of the charge, a UJR would not be, probably not be granted in this case, Judge, but we would ask the court to consider, because some of the new revisions to the code, Judge, but we would ask the court to consider setting a low bond so that Mr. Bowie can make it.
And just like that, things take a turn. Mr. Bowie's 21-year-old son joins the call. He's not just a witness, he's the alleged victim, but instead of hostility, we hear compassion. He openly says he's living from friend to friend, waiting for his father to return. It's a moment that breaks expectations. This isn't a straightforward case of violence, it's a complicated portrait of family collapse, economic hardship, and emotional dependency. Here's the question for you. If the alleged victim isn't afraid and wants his dad home, should that influence bond decisions?
The alleged victim in this case, his son, is currently on the call, and I would like to ask him some questions just in reference to whether he feels that Mr. Bowie being released would be would put him in any kind of fear, or if he's in any fear of Mr. Bowie violating his bond conditions there. But Joe, Mr. Bowie has not had an opportunity to get out on bond on this case. He does maintain his innocence. And
Okay, who's the alleged victim in the case?
his son.
How old is the son?
21
Where does he live?
with me.
Oh, not anymore.
But
Not
not anymore.
Who is currently in the house?
We don't have a house no more, Yana. We go to crib.
He wants to what?
we lost our apartment right now, so he's currently living with a friend right now. He's living from friend to friend until I get back home.
And
Okay.
he is on the Zoom call, just so the court's aware.
All right, so Mr. Bowie, I don't know what happened. But I will say this, it's hard for adults to live together. And I know a lot of people are in the financial situation. Just hear me out. You're looking at me crazy, but just hear me out. I've been doing this a while. It's hard for adults to live together. And you're looking at financial situations where people are like, yeah, we're gonna stay here. And my adult son is gonna live with me in the house and he's gonna help me with the bills and we're gonna be able to do this. And a lot of times that doesn't work.
This is where Judge Boyd drops the hammer of truth. With years of experience behind that bench, he cuts through the emotional fog. Two adults can't always live together. His message? Love doesn't erase reality. Rent still needs paying. Rules still need following. And parenting grown children, especially in close quarters, can explode fast. It's not just a legal ruling. It's a life lesson on generational struggle and blurred boundaries. And let's be real, how many of you know someone stuck in a similar situation?
And so I don't want you to say anything that might jeopardize your defense. But what I say is a lot of times parents think they're doing the best that they can by either living with an adult child or having that adult child live with them in their space. But a lot of times, because you got two adults in a space, don't nobody want to follow anybody else's rules. It doesn't always work out like you think it should. And even though you think some of these family situations will blow over and they can be repaired by the time we get to this point, y'all have already made up or whatever. But the problem is that's not how the court looks at it.
Okay.
And so sometimes you have to understand that even when y'all see it differently, like that's just, we squashed that beef, it's water under the bridge. That's not how the courts look at it. Okay, so what I say is sometimes it's easier for y'all, if it's a financial thing, for y'all to each get roommates and not live together. But you keep looking at me crazy.
Ms. Judge, can I say something, please? I haven't got a chance to talk at all.
Go ahead.
Situation.
Here comes the emotional gut punch. Mr. Bowie finally speaks, and it's raw. His mother passed away, he moved down to Georgia with his son, and now he's lost everything. He insists he never touched his child, and you can hear the desperation. In his voice, he's not just fighting a charge, he's clinging to his last thread of family, dignity, and purpose. This moment matters because it's not about guilt or innocence. It's about understanding the human being behind the file. Number 2.
Like my mother passed away down here. We came down here to Loganville, Georgia. My son and me is the only people we have. I never put my hands on my son. That's why my son is spoiled. He's 21 years old. I'm waiting for him to get his situation right, for him to get him a car and all that right now. I'm the breadwinner. I don't need.
But Mr. Bowie, what I'm saying to you is he's 21.
I know, Judge. Everybody tells me that. That's true.
But I'd say it to so many parents, and then when y'all get in this situation, I'm supposed to understand that you ain't do anything and he's spoiled. I get that. But no, New York, hold on, New York. I get that. But what I'm saying is, as a
And now, Judge Boyd goes full real talk. He says what many are afraid to admit. Sometimes we coddle our kids until it hurts them and us. He calls out parents who prop up 21-year-olds who should be standing on their own. He even admits, you buck up against me, I'll put my hand through your chest. It's dramatic, sure, but it's also packed with truth. This is less about law and more about what happens when love becomes a crutch instead of a launch pad. Comment below. Is the judge too harsh, or is he saying what needs to be said?
Parent, and as somebody who was raised by a single mom, for the most part, I have a stepdad who helped raise me. The point is, a lot of times we spend so much time coddling these kids and they never feel the rough side. And then when it comes time for us to discipline them, they buck up. And if you old school like me, you got one time to buck up against me and I'm gonna put my hand through your chest. Now I might go to jail, but I'm gonna put my hand through your chest. So what I say to you is, we keep saying, well, we're helping them, but are we really? because what we're doing is making them irresponsible. Let me ask you the question. When did you leave home? What age were you?
15.
It's always the parents who left home at 15, 16, 17. I get you know how hard it is out here on these streets, but you made it. But you're going to coddle his 21-year-old butt. And then this is the situation you in. Y'all don't have a home because you lost it. You don't have a job because you lost it. And he is talking about, you know, let my daddy out. Well, this is a situation caused by two adults who can't live together in the same house. And when you tell me, well, see, let me talk. I understand this situation much better than you think I do, because I see it all the time. And it's always the parent who loses, because even if the child goes to jail, the parent is trying to put money behind, money on their books, pay their bond, pay for a lawyer. What I'm telling you is I get that it might just be the two of y'all, but two grown people sometimes, especially if they know each other, have difficulty living together. While you sitting there trying to prop him up to get himself together, what is he doing? Is he in trade school? Is he in college? Is he working?
Yeah, he works at Kroger. And I was taking him to work at, like, I hear what you're saying. Like, I'm taking him to work every day. Now he has to take an Uber. He works at Kroger factory. He doing good. He making some money, but I was taking him to work every day and making him save his money so he could buy his car. And that's why, like, I have another daughter too. So he got kind of a little jealous of her, me teaching her how to drive. That's how we got into this argument. And that's how we got into this fight.
Get that. But what I'm saying to you is he's 21. He's a full-grown man.
Yes, I understand that now, Judge, from being in here with a lot of 19, 18, 21-year-old killers that I'm in here with now. I understand that now. I didn't understand that before. Like, you sound from New York. I came down to Georgia, and I ain't want him to be like me. Like, my mother left us some money, you know what I mean, to make sure he was good. He graduated from Grayson High School in Loganville.
The fallout becomes crystal clear. They lost their home, Mr. Bowie lost his job, and all of it, according to the judge, stems from two adults trying to share a space without shared rules. But here's the kicker. Mr. Bowie didn't just house his son. He drove him to work, helped him save, and even supported a daughter. He did everything right. So what went wrong? This is the heartbreaking part where doing too much as a parent turns into a court case. Would you have drawn the line earlier or kept helping like Mr. Bowie?
So, you know what I mean? Like, I couldn't afford to send him to college, so I was trying to make him get his H back. So
I get that, but even if you can't afford to send him to college, you know how I went to school? I took out loans. I worked 2 jobs in college. So it is not impossible to do. And while parents keep wanting to do everything, I had a job where as soon as I finished school, I was on the bus headed to my job. I worked that job, came home late at night, went straight back to campus. It was every single day, 7 days in a week. I was either working and in school or working or in school every single day, 7 days a week. I never had a break. So what I'm telling you is he can do that, but you got to let him fall. A lot of times we as parents keep propping these kids up, and then it's to your detriment. Now he on the call wanting everything to be all right, to tell me it's all good and I need my daddy to be out. But he doesn't understand that he needs to be out there making his life do what it do. You grown now. You don't owe him anything past the point of 18.
That's right. I know.
And so you driving him to work, you making sure he do this, you making sure. All we doing is making kids weak. When I was in high school, I had 2 jobs. So what I'm saying is, let's stop propping these babies up. Let's give them the opportunity to be responsible and do what they need to do. Because when we keep holding them up and they never feel the rough, they don't know what it's like. And then they're gonna buck up against you. No. Okay.
I understand.
So, I don't have a problem.
Can I say one more thing, Judge? What about the 30 days they just made me do for, and I have the paperwork that I wasn't on probation no more.
I got you, sir. Look, we'll take all that into credit. What I'm gonna do is
Finally, we get the legal resolution. After intense back and forth, the judge sets a $2,000 bond, but with one strict condition: no contact with the son until the case is resolved. Legally, this is smart. It protects both parties, even if they claim to be on good terms. But emotionally, it's a painful separation. This father just wants to get back to his life, and now he must stay away from the very person he fought so hard to raise. That's the paradox of family violence cases. Even love can't override the law.
Knowing the nature of the situation, as long as you and your son don't have any contact with each other, I will give you what, he has no bond on any of the charges?
No, Judge. Well, sorry.
Does he have a history of any kind?
He doesn't have a bond on the, I believe can you pull it up, Tess, what his bond situation? I know he doesn't have on the battery family violence.
Only have him charged.
Or-
That's
actually,
all I see.
Yeah, that's sorry, that's right. That's the only charge that he does have. So he's.
Okay, so, I'll give him, a $1,000 bond on each of the charges, and he can do property. He can do, cash, he can do bond company. I don't care.
Okay, Judge. So you want me to draft an order to that effect? Or?
Yeah, as
Okay.
long as there's no contact with the son until this case is resolved.
Okay, and that's a $1,000 bond for the pending charge.
For what now?
That's a $1,000 bond per the, I believe it's one count.
One count.
Now, I'm looking at 4 counts.
Oh, I'm sorry, but so it would, they're lesser included, right, Judge? So it would be,
What?
so it's like battery family, the way we typically see battery family violence, battery, simple battery. family-
Yeah, those 4.
So those would be lesser included. So you want $1,000.
Okay, so then a $2,000 bond on the battery family violence.
Okay.
And
So,
the other ones, because I don't know how you want me to count it.
well, so Judge, my concern, obviously I want the lowest amount for my client, but what I want to make sure that what I submit is something that the sheriff's office will understand how to, because he's only held on battery family violence. I understand that the accusation has.
Well, I was talking to somebody at the jail recently about that, because I was trying to figure out how we're supposed to do it. And she was telling me that if we put the bond on the charge he's held on, then the
Right.
rest of it should work out.
That's what that's.
Okay, well,
my
then
understanding.
revise that to be a $2,000 bond on battery family violence, and then the rest of them will work themselves out. If you have to split them, then split them among the 4. If you don't, then put it on the first one.
Okay, Judge, I'll submit an order to you as soon as we.
Okay, so whatever would give him an aggregate $2,000 bond.
Okay. Thank you, Judge.
Okay,
What started as a simple bond hearing became a gripping story of love, loss, and the limits of loyalty. Mr. Bowie will finally get his chance at freedom, but the personal cost is steep. Judge Boyd didn't just hand down a bond, he delivered a life lesson on parenting, boundaries, and what it really means to let go. This case proves that the courtroom isn't just where justice is served, it's where families break, bend, and sometimes begin again. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. We break down the truth one case at a time.